in order to understand what the new law is, I think it's helpful to understand where we've been. Okay? So let's start off prior to January 1, 2010. The estate tax exemption, which is the amount that can pass free of estate taxes to anybody other than a U.S. citizen spouse, because incidentally, there's an unlimited amount of wealth that you can pass to a U.S. citizen spouse. But just prior to January 2010, for the tax year 2009, the federal estate tax exemption was $3,500,000. That was the amount that, for example, a parent could leave to their children in the aggregate, $3.5 million. If the decedent's, and I use that term a lot, the decedent's estate exceeded $3.5 million, then there would be an estate tax concern. But if it was less than $3.5 million, we were going to pass free of estate tax. And incidentally, that was a significant increase over where it was when I started practicing, which was $600,000. It had started to creep up, the estate tax exemption, under some laws that were in place during the Clinton administration. And then President Bush implemented a much further increase where the exemption was going up from a $675,000 exemption up to $3.5 million. And then in 2010, no federal estate taxes. So as we were getting close to the end of 2009, those of us in the field were saying, they've had all of this time, Congress, to act, to come up with some plan. I cannot believe that the estate tax is just going to go away. And by the way, it went away for 2010 under the Bush tax cuts. But remember, the Bush tax cuts were scheduled to expire at the end of 2010. So what we were looking at is, yes, there would be no federal estate tax in 2010, but in 2011, the Bush tax cuts expire and the estate tax comes back with a $1 million credit. So it was really like Alice in Wonderland trying to do planning in this environment, especially where you certainly didn't know when clients were going to pass away. We had issues with clients who were not well and trying to figure out what to do. So let's go back. So prior to January 1, 2010, the estate tax exemption was $3.5 million. We also have a federal gift tax in this country, which a lot of people are surprised by, and the exemption was $1 million for federal gift taxes. Again, that's exclusive of what one spouse can leave to another U.S. citizen spouse. The federal estate and gift tax rates were each set at 45%, so a rather onerous tax once you got over the exemption. And the estate tax exemptions were what we call use it or lose it. And what I mean by that is, on the first spouse's death, let's assume it was the husband, if the husband left everything to his wife, she would inherit everything tax-free, but his credit that he had, which in 2009 was $3.5 million, would have been wasted. The wife would not have the opportunity to use his $3.5 million credit. She may very well have her own credit, but she didn't get the benefit of his credit. So what we used to do back then is planning, where we call various names for it: two-share wills, credit shelter wills, bypass trusts, which was a method by which we could utilize the first spouse's exemption. We would establish a trust on the first spouse's death, and we would fund that trust with an amount typically equal to the federal estate tax exemption. Okay, great. Equal to the, is that better? Equal to the federal estate tax. You know, I was hearing just fine up here, so I don't know what's the matter with you all. Got to get your hearing checked. So we would establish a trust on the first spouse's death and utilize the first spouse's exemption, so it wouldn't be wasted. And what we'd do is we'd put that amount into a trust. The surviving spouse would get the use of that trust during her life, but at her death, the assets in that trust would not be added to her taxable estate. So let's take an easy example. Husband has $3.5 million, wife has $3.5 million. On the Am I good?
No, you asked what you wanted to tell me.
Okay. Husband had $3.5 million, wife had $3.5 million. What we would do is, on the husband's death, we'd take his $3.5 million, put it into a trust for the benefit of the wife. So the wife would have her own $3.5 million, and the use of his $3.5 million, which was in this credit shelter or bypass trust, at her death, when we're counting up her assets to determine the value of her taxable estate or her gross estate, we would not include the assets in that trust. And the reason for that is, and we use this example all the time, she's sort of like a renter. She's not an owner, she's a renter. She gets to use it during her lifetime, but she doesn't own it. So at her death, it's not included in her estate. So we would create that trust on the first spouse's death and leave everything to the surviving spouse. There'd be no estate tax on the first spouse's death. I'm not covering New Jersey tax just yet, but no estate tax on the first spouse's death. Second spouse's death, we look at just her assets. We don't look at his assets in the trust, and we get to double up on the credits that way. And that sort of planning has been going on for quite a long time.